Over the last 2 years, the Law Commission has been looking at disabled children's social care law in England. We've now published our final report, making recommendations for reform. We were asked to carry out our review by the Department for Education, following a recommendation made by the 2022 Independent Review of Children's Social Care. When we talk about disabled children's social care law, we mean the legal rules which decide whether a disabled child can get help from social services to meet their needs, what help they can get, and how they get it. One of the main problems with disabled children's social care law is that it is overly complex. There is no single piece of legislation or guidance which a family or local authority can go to find out what their rights or responsibilities are. The rules are found in a patchwork of legal provisions spread across Acts of Parliament and regulations. These rules are added to by a number of different pieces of types and guidance setting out how legal rules are to be applied. There are also important court decisions interpreting the law. It can be tiring and frustrating for families and carers of disabled children to navigate all these provisions. The law is also out of date. It uses a definition of disability that dates from the Second World War, which uses words which we now see as offensive, like handicapped and deformity. The law also hasn't kept up with more modern understandings of disability, such as autism and other forms of neurodiversity. Moreover, the law is arguably unfair. As a result of a court decision, local authorities can design their own eligibility criteria to determine which disabled children receive care. What this means is that a disabled child in one part of the country may have their needs met by social services, but a child in another part of the country with identical needs may not. That wasn't the intention of the legislation. In practical terms, it means that there is a postcode lottery of support across England. We have talked to families, carers and professionals, as well as disabled children. Families have told us that the law is applied in a way which makes it difficult for their children to get the services they need. Many families and professionals have told us that there is too much focus on safeguarding disabled children from harm at the expense of meeting their needs. Disabled children are often viewed as children in need of protection rather than children in need of extra help. Disabled children have told us that they feel their voices may not always be heard and that the help they receive does not always prepare them for making the transition to adulthood. To help make the law clearer, our report recommends a simplified, unified legal framework for disabled children's social care. These legal provisions should sit within the Children Act 1989. There should also be one clear, comprehensive set of guidance on disabled children's social care. This should include material that helps local authorities to ensure there is a more appropriate balance between identifying and meeting the needs of disabled children and their families, and safeguarding them from harm and abuse. This should be done in a way that does not stigmatise families and carers. To bring the law up to date, we are recommending an updated definition of disability. To alleviate the potential for unfairness, we are recommending that there should be a single duty to meet the social care needs of disabled children with national eligibility criteria for England. As a first step to achieving this, we are recommending that the government consult and work with disabled children, their families and local authorities to determine these criteria and ensure that these are financially sustainable. We also make other, more specific recommendations. For example, rights for disabled children to participate in decisions about their care and support, including support for their transition to adulthood, alongside access to advocacy for children and their parents and carers when needed, and the need for a fair, accessible, independent and effective system for resolving disputes about social care for disabled children. The reforms we recommend represent the most substantial change to this area of law in over 35 years. Taken together, we think the reforms will provide a more modern legal framework better suited to meeting the specific needs of disabled children and their families. Our recommendations should help to make the law clearer, simpler and fairer. Our report was laid before Parliament on Monday the 15th of September 2025. The government will then look at our report and decide how it wishes to respond to our recommendations. The relevant minister has 6 months in which to provide an interim response to this report and a year in which to provide a full response. The government can decide to accept or reject our recommendations or to implement them in a modified form. In deciding on our recommendations, we have been helped by many contributions from disabled children and their families, social workers, and many others who know about this area of the law, including managers and directors at local authorities, academics, and lawyers. We are extremely grateful to everyone who has contributed to the review and helped to shape the reforms we recommend.